Balik tayo dito sa Kababayan Today. We are taking your calls here on our show. Kasama po natin si Attorney Allison Aquino-Silva at si Attorney Richard Loew. And we have on the phone with us si Alex. Alex, ano po ang tanong ninyo para sa ating immigration attorneys?
Yes, alamin ko lang kung yung isang bata na approved na sa DACA, ay pwede pa siyang ipetisyon?
Yes, absolutely.
Okay.
And so a child who has already been granted DACA, they can still be petitioned. And you absolutely do need to move forward with a petition because the DACA program does not lead to a green card. So absolutely, you do still need to move forward with presumably a family-based petition in order to get the child the green card in the long run.
All right. Thank you very much for that. All right. Kasama naman natin, we have an anonymous caller.
Hello?
Hello. Ano pong tanong ninyo?
Gusto ko lang tanungin kasi yung anak ko, pinitisyon ng father niya noon, 1999, kasi nakarating na yung mga kapatid niya, naiwan lang siya kasi nakitaan sa blood niya na may may marijuana raw. Tapos binahan siya ng 3 years. Ngayon, after nung ban niya ng 3 years, ako naman, naayos ko naman yung pabil ko, pinitisyon ko siya at immigrant lang ako. Tapos nag-asawa naman siya. Ngayon, hindi na namin alam kung anong gagawin namin para ma-petition namin siya ulit.
Okay, so someone was petitioned. They found marijuana in his blood. He was banned for 3 years. They did re-petition him. However, he got married, and so at this point, they really don't know what they can move forward with.
Yeah, this is actually an interesting problem, and you find this, that when people go for counselor processing and they go do their medical exams, that at that point they reveal usually to the doctor that they had been doing marijuana or something else, and you end up with this 3-year ban. Now, it doesn't stop the visa process. They shouldn't have had to have filed again. They should have just needed to wait those 3 years and then go back and reapply again to the consulate to move forward with that process. But now that that person is married, you can only be a citizen and petition your married children. So the only way to petition a married child is to be a U.S. citizen. So the petitioner has to be a U.S. citizen.
Yeah, because they were just an immigrant.
Yeah, so that process needs to go forward through first the person becoming a U.S. citizen, then petitioning for their children.
That's right. If you are here in America and you have not yet filed for your citizenship, don't wait another day. I know a lot of our Filipino kababayans that have waited, and they'll get around to it. But as we know, it's so important that if you have the opportunity to do it right away. Okay, kasama naman natin si Edith on the phone. Edith?
Yes, hi. Hi, G.
Hello.
Attorney Aquino, I have a question to you guys. A friend of mine has a pending petition from her mother and employer for almost 10 years.
Mm-hmm.
Her husband died last night, unfortunately. She wants to go back to the Philippines. Do you think she can come back, or what is it that we can do so she can get a temporary visa to go back and forth to the Philippines?
And my condolences, first of all, to your friend. Unfortunately, even in situations such as that where there is a death in the family, oftentimes that's the most heartbreaking part of what we do, is that sometimes there's nothing that we can do in order to facilitate the travel, because there are 10-year bars or potentially other types of bars that would prevent the re-entry back into the United States. In her friend's situation, she mentioned that she had both an employment-based petition and a family-based petition that has been pending. So if by chance your friend has the priority date current on either one of those petitions, then she should go ahead and move forward with the application for adjustment of status. At that time, she can also apply for advanced parole, which is a travel document that would allow that exit and re-entry back into the United States. Anytime that a person who has been out of status departs the U.S., even on advanced parole, they should, however, first speak to an attorney, because there are some situations where people have the false assurance that they're going to be okay because immigration has granted that advanced parole document. Before you even apply, you should probably get a consultation, because unfortunately immigration will issue the travel document, but it doesn't necessarily mean that you're going to be allowed to come back in.
Yeah, so sayang ang pamasahe, right?
Well,
you don't want to spend for that if you know, you're not allowed back.
Absolutely, but there is a potential, there is a possibility, and so her friend certainly should go ahead and seek consultation with regards to her particular situation.
Okay, kasama naman natin si Nenita sa telepono. Nenita, nandyan po ba kayo?
Hello.
Hello po. Ano po yung tanong ninyo?
Ang tanong ko, yung dalawang overage kong anak na babae sa Pilipinas, approved na yung petition nila.
Okay.
Kaso, nung 2011 approved. Kaso, gaano pa katagal sila makakarating dito?
Okay, so we were speaking about this just earlier. It's that big word I can't say, retrogression, right? So 2011 sila na petition. When can they arrive?
And so actually she said 2011 was approved.
Oh yes,
and
approved.
so the priority date is actually set by the date that the petition is filed with immigration, not when it was approved. So she should take a look and see when the petition was filed, take a look at that priority date. If it's a green card holder who petitioned for unmarried children over the age of 21, which it sounded like was that situation, right now the priority date is at 2004. So if it was approved 2011, hopefully it was filed years before that, but right now it's at 2004.
Okay, all right, so we will be right back here on Kababayan Today. We are taking your phone calls. Please give us a call at 1-800-553-5724. We'll be right back with Aquino and Loew.